Welcome, everyone, to the newest installment of the DOA Podcast with Jeff Ward. I am Jeff Ward, and of course, DOA stands for Decisions, Opinions, and Analysis. And we're going to lean towards the analysis portion of that trio today as we continue to talk about the Shadwick King retrial going on right here in the Kane County Judicial Center in St. Charles, Illinois. A great part of the reason for doing what will likely be a very brief update is because one of the listeners on the previous podcast on this topic, which you can find on thefirstward.net, all spelled out, lamented the fact that I kind of applied more opinion, I don't know, I am an opinion columnist, than I did my reporter skills. They claimed they wanted to know what was going on inside the courtroom. And the issue there is that no journalist has time today to sit through a multi-week trial, particularly of this nature, to the exclusion of everything else. In fact, if it weren't for the Daily Herald's Susan Sarkowskis, I'd be just as lost as everyone else because I'm relying on her to feed me the information about what's going on. And the only reason Sue has been able to semi-regularly attend the proceedings is because she got dispensation from the court to work on a laptop while she's sitting in the gallery. For anyone who's ever sat in the gallery of a courtroom, you already know that you can't read a newspaper, you can't play with your cell phone, you can't work on a laptop unless the judge specifically grants you that privilege. And when you consider my regular criticism of the 16th Circuit men and women in black, I'm not so sure I would get the same consideration if I asked for it. So this works out better for everyone involved. There was a day when suburban media outlets could spare a reporter for a week or two, but those days are long gone. We're talking going back to the early 2000s. 20 years ago. All right, with that caveat issued, let's move on to what is going on in the courtroom and pretty much what's happened up to last Thursday. June 23rd is the prosecution presented their case. Again, I'm not going to go through all of the background that is contained in the last episode on the King retrial. If you need to catch up, I would highly encourage you to listen to that one first. That said, I will remind you that Greg Sams is the lead prosecutor on this case. He's an adequate attorney. I don't think he's the best choice for this trial. I think Bob Dorr I can't remember the other one's name, another one of the felony prosecutors in the Kane County State's Attorney's Office would have been a better choice. But I believe, given Sam's seniority, he's the one who got to make the call as to whether he tried this one or not. And what Sams did is put on your average legal journeyman's circumstantial case, because that's all he has. But when you consider the possibilities in this trial, when you consider the Columbo-esque logical line of events that most likely happened, that's pretty much all any prosecutor has to do. Unless defense attorney Kathleen Zellner comes up with some bombshell, I just don't understand how she's going to create reasonable doubt, particularly in the mind of a judge, because if you recall, she went for the bench trial. So again, the prosecution put on their basic case, which is all they had to do. They rested last Thursday, and as is the case in every major criminal trial in this country, Kathleen Zellner moved provided a motion, issued a motion for a directed verdict. Now, for those of you who followed my legal history, that's something with which I'm quite familiar. But essentially, when an attorney asks the judge for a directed verdict, they're saying, hey, judge, the prosecution did so poorly that no reasonable juror or judge would convict based on the evidence so far. But in order to get a judge to grant you a directed verdict or a summary finding of innocence, well, not guilty, the bar is incredibly high. The first thing the judge has to do is view the evidence that's been submitted in the light most favorable to the state. We're not talking about reasonable doubt here. We're not talking about preponderance of the evidence. To have a motion for a directed verdict granted, the prosecution has to be woefully inadequate in their case. Take me, for example. I've received 2 consecutive directed verdicts against the Geneva police. My friend and attorney Jeff Meyer and I kind of calculated the odds, and all things considered equal, the odds of a defendant getting 2 consecutive directed verdicts against the same entity with the same prosecutors involved are 1 in 40,000. So again, the evidence has to be viewed in the best light for the prosecution, but if the prosecution hasn't begun to prove their case, you can get a directed verdict, as rare as it is. But if I was a betting man, and I am a betting man, and I talked at length with Sue about that possibility, there's no way you're going to get a directed verdict in this case. There's no way the state, well, I suppose there is a way, but it would be really, really difficult for the state to screw up the circumstantial case. You've got the text between Kathleen King, Shadwick's wife, and her ostensive lover. You have a woman seemingly running on the railroad tracks, which is a virtual impossibility, as anybody who's ever walked on that massive pumice stone can attest to. It's difficult to run on the tracks, too, because you have to hit the railroad ties. And, I mean, between the discovery of those texts, indicating an affair on the part of his wife, and her being found dead, who else could have intervened within that brief time? And also, again, did a woman whose blood alcohol content was 0.15, the day after she supposedly had 13 drinks, I mean, I come from a long line of alcoholics, and I couldn't run if I was anywhere near 0.08, 0.15, of course, being virtually double the legal limit to get a DUI. Defense attorney Zellner's main claim for the directed verdict was that the prosecution hadn't tied Mr. King to his wife's murder. But how could they? Okay, oh yeah, we found her DNA in the trunk of the car used to move her to the railroad tracks. Again, that's a presupposition. Well, of course her DNA is going to be in the car. She was his wife. Well, we found Shadwick's DNA on Kathleen. Of course his DNA is going to be on his wife because they live together. So it's a bizarre argument when there are certain realities involved here, and, circumstantial evidence is evidence. It's a bit of a higher standard. You've got to, be a little more, the evidence has to be a little bit tighter, but people get convicted on circumstantial evidence all the time. So as you might imagine, on Monday, June 27th, Chief Felony Judge John Barsani, who's hearing this case, again, we covered that in part 1 or the last podcast on this topic, ruled against the directed verdict, to absolutely no one's surprise whatsoever. So now the defense has to put on their case. And I'm a little surprised at their next step, which was essentially to put Shadwick King himself on the stand. And even though it's a little less dangerous with a bench trial, whenever you put a murder defendant on the stand, it's an all or nothing proposition. You're risking the whole case because despite the fact that you're going to practice and re-practice their testimony, which is legal, if they don't stay on script, they can accidentally open the door to all sorts of prosecutorial evidence that wouldn't otherwise come in. Not only that, but most folks aren't used to being grilled like a cheeseburger. And I don't, again, I think there are other Kane County prosecutors who could have potentially rattled Mr. King a bit on cross-examination. But particularly if the defendant is lying, I'm not saying he is or isn't in this case, it's too easy for a prosecutor who does this day in and day out to trip them up, to have them make a mistake, and your case immediately goes down in flames. And if you're going to have the defendant testify, the whole tearful defendant thing, the whole bit, I'm sure, that Shadwick will say, I didn't do it, I love my wife. might work with the jury. It might get a jury or a couple jurors a little emotional and they might believe him. But it's not going to work with a veteran judge. It's not going to work with Judge Marsani, who was a 40-plus year prosecutor, including at least 8 years as the Kane County State's Attorney. Because in the end, Mr. King can't prove he's innocent by his own testimony, and I'm sure Greg Sams is licking his chops. He can't wait to cross-examine him and try to get him to make one of the mistakes we just discussed. Again, he can open one misstatement, just a sentence of going off script, and you can open all sorts of doors for the prosecution that now can't be closed. You know how they say it in trials, you can't unring that bell. I'm also surprised that Ms. Zellner basically put King on first at the outset of the defense. I mean, typically you'd think, clearly she's got to have experts ready to testify as to the facts as she sees them. And my thought would be that you have all those folks testify, and then you get, and hopefully instill some doubt, and then you get the tearful defendant to make that final statement. It also allows you to, how do I say this? It also allows you to better judge, to better determine what the best testimony on the part of the defendant. How does his testimony fit in with what the experts said? I mean, I suppose you could do his testimony and then have the experts prove it, but I don't think that's nearly as effective. I suppose in the end I'm saying that the risk isn't worth any potential reward because I don't think any reasonable judge is going to be swayed by a defendant's testimony when that defendant can't possibly prove their innocence. But as far as what's going on in the courtroom, that's exactly what's happening as this podcast is being recorded. And despite the fact that I, and now you, have a little more knowledge of the process of this retrial, nothing has certainly convinced me beyond any reasonable doubt that the verdict is going to be any different than the first trial. Again, the circumstantial evidence is simply too much. Who else would have murdered Kathleen? Would a 32-year-old, reasonably healthy woman go out running on railroad tracks and then collapse when she's still drunk, very drunk, and then collapse of some unknown malady? Again, Kathleen and her purported paramour exchanged 3,000 texts in 2 weeks. I mean, I'm sure I have, but it's funny to say I'm not sure I've issued 3,000 texts in my entire life. So the question is, how is Kathleen Zellner possibly going to instill the kind of beyond reasonable doubt required for a not guilty verdict in front of a veteran felony court judge? I just don't see it. The circumstantial evidence is just too much. And as you might imagine, I have talked with all manner of legal folks on this topic, and they all agree on two things. One, everyone is shocked that Ms. Zellner went with a bench trial. And I think that is going to be her ultimate undoing. It was already a steep hill to climb when considering the circumstantial evidence, but once she decided not to put it in front of a jury, I think that was the beginning and ending of the case. And I've asked around about that because, again, Ms. Zellner has a great reputation. She's known for overturning wrongful convictions. But what I've recently learned is, while she's spectacular at writing the appellate briefs, those to overturn a conviction, which is a real art form, trust me, because it happened on my behalf. She's not a trial lawyer. And I understand that her first chair is truly attempting to kind of bring his experience into the fray. But I think Ms. Zellner, like most of us, overestimated her ability, and this one isn't going well for her. I also want to remind you that there's going to be no Perry Mason moments. I mean, I love that show, but the laws of discovery prevent those kinds of surprises. Again, it's like in My Cousin Vinny, that bullhork scene where, Joe Pesci, Vinny, walks over to his paramour, Melissa Tomei, and says, "Hey, look what the prosecution gave me. Come on, man." Anybody who made it through the first year of law school knows the discovery rules and know that both sides have to exchange everything they have. Because if they don't, particularly the prosecution, you're going to get a mistrial, and, then you got to gear up to do it all over again. Again, I understand why Mr. King likely accepted Ms. Zellner's offer to defend him at no charge, or pro bono, I suppose I should say. But I think he would have been far better off going with the Kane County Public Defender. I hold public defenders in the highest esteem. They make the legal world go round, because as we have, our constant running theme throughout the coverage of this retrial is that everyone is entitled to a zealous defense, because to do anything else renders trials nothing more than theater. Then we'd be no better than third world despots. So since the prosecution took a bit more than a week, in fact, almost 2 weeks to put on their case, I'm assuming that the defense will continue to present their case through the end of the week, which would mean June 30th. And while trial experts can be very convincing people, I've seen some great ones. They tend to have more of an effect on a jury and not a judge. And in this case, Ms. Zellner's theory of what might have happened is so outlandish that I don't think her experts are going to have any effect at all. I'm sure one of them's going to testify that Kathleen had an undiagnosed or a misdiagnosed defect of some sort that led her to collapse on the railroad tracks. But come on. I mean, who goes out running on the railroad tracks when they're still at double the legal level of intoxication? And who runs on railroad tracks? And who else would have wanted to murder her if it wasn't some sort of physical issue? I know an expert is going to testify about, metal flecks in her running shoes, but they live near the railroad tracks. Any Geneva, Illinois, for you non-Illinoisans, any Genevan can pick those up, crossing 3rd Street to go to the variety of restaurants, crossing the Western Avenue crossing to run, and any number of other means. And unless you can tie a specific metal compound to railroad tracks, to the rails and the spikes, it's not going to be very convincing. And it's going to be particularly unconvincing in front of a judge instead of a jury. Again, I think the massive error here, and every legal expert I've spoken with, I'm not going to get into them because I don't, you never give up a source, agrees and is shocked that the defense went with a bench trial in this case. So there you have it. That's what's been going on in the case. I bet Mr. King is either continuing to testify as I speak, or he is being cross-examined. I will do another podcast on the final verdict. If it goes on for longer than this week, I will likely do another one on the defense's case. But for now, this is the best I can do as one journalist sitting in my home office, unsupported by a newspaper or a media company. I wouldn't have it any other way, but but you guys have to understand my limitations. So I'm still predicting a guilty verdict. I don't know if the sentence will change. And if there is another guilty verdict, I'm sure there'll be another appeal. Again, thank you for listening to this podcast. I really do enjoy performing these kinds of legal analyses. My mother used to say I should be a writer or an attorney. I swear I chose poorly, but I enjoy it nonetheless. You can also find all of the columns described here, all the podcasts described here on thefirstward.net, all spelled out. My YouTube channel is up and running, the DOA Podcast with Jeff Ward. I don't know if YouTube's internal search engine has caught up with it, but there were, as I've said, a number of listeners on the first King Retrial podcast. Of course, if you have any thoughts or suggestions, I can ask my various sources, including Sue, for their theories, and I'd be happy to do it. If you'd be reasonably respectful of the effort I put into these things, I'd appreciate it. But trust me, after 16 years at this game, I'm not expecting anything different. So this has been the DOA Podcast with Jeff Ward. DOA stands for Decisions, Opinions, and Analysis. There will be far more to come in the podcast area in general. In fact, I'll shortly be doing one with the aforementioned Jeff Meyer on the new Illinois law that makes drunken sex illegal. Again, thank you for listening to the DOA Podcast, because without you, there'd be no conversation.